This is the first video in the introductory course for weeks 3 to 4. It's a screenshot video. I have up on the screen the posting entitled Activities of Attorneys Engaged in the Practice of Law. What we want to do when we talk about this posting is first identify a very important definition or concept, namely what does practice of law mean, and then we would take a look at how attorneys are practicing law to see if we could get some practical understandings about what lawyers are doing, because if we can figure out what lawyers are doing, as I've been mentioning before, we can figure out certainly where paralegals are and the kinds of assistance they're rendering lawyers. But first, to the definition of practice of law. The significance of this definition is that one needs a license to practice law, and if one is engaged in the practice of law without a license, we can call that the unauthorized practice of law. We could say that it's a dangerous activity because the unauthorized practice of law is in New York State a crime, and under certain circumstances could rise to the level of a felony. Paralegals and lawyers have to be careful then that paralegals, however valuable their assistance is, and I'm telling you it's very valuable, paralegals cannot cross over the line into the practice of law, and if they were to do so, it would certainly jeopardize the professional license of the attorney. It would result, I suspect, in a bad employment outcome for the paralegal, and perhaps in an extreme situation could result in someone being accused of criminal activity. But let's just get, for now, a useful definition of what the practice of law is. And as I put out above, we'll take a look further in terms of some things that paralegals should be thinking about in this area. But our working definition of the practice of law is that it consists of representing another individual or entity in a tribunal where a license to practice law is required, or providing legal advice to a person or entity about a specific legal question or issue. And as I note, we can make a few observations. What do we mean when we say practicing law or representing another person or entity in a tribunal where a license is required? A tribunal is a place where legal disputes are resolved. Certainly courtrooms are a tribunal, but so too are arbitration proceedings and administrative hearings. And the court is a tribunal where a license to practice law is always required. Put differently, no one but a licensed attorney can represent another individual in court. But as to these other tribunals, administrative hearings and arbitration proceedings, oftentimes we see that there's no requirement that the advocate, the person who's representing someone, be a licensed attorney. And I know when I was in law school, I was representing individuals in administrative hearings. When I was working for a neighborhood legal services project, and I didn't have a license to practice law, but the rule of the tribunal where those administrative hearings were held did not require a license to practice law. I still do a lot of arbitration proceedings where I represent employers and labor arbitration, and oftentimes my opponent, the union advocate, however skillful she or he may be, is not a licensed attorney, because in that tribunal also there's no requirement that there be a license possessed by the advocate. I also noticed that the definition is representing another person. One can always represent himself. We call that pro se representation. Then the last part of the definition, providing legal advice, we're talking about giving legal advice to a specific person or entity. When I say entity, a company, a corporation, a municipality, something like that. So a person or entity about a specific legal issue or problem. And I note that there's a famous case behind this, but if a non-lawyer were to write a book offering legal advice to the general public, that would not be offering advice to a specific person about a specific problem or issue, and that would not constitute the unauthorized practice of law. We'll say more about the unauthorized practice of law later when we get into what paralegals should be thinking about. But the last part of this posting, we get into the activities of lawyers that constitute the practice of law. And what I've done is, sort of arbitrarily, but I think in a way that makes sense, I've broken it up into three different categories. Lawyers represent people in litigation. Lawsuits represent people in transactions. For example, when people buy or sell a house, or perhaps the transaction is creating an estate. Perhaps the transaction is someone has died and we're administering the estate. Perhaps the transaction is setting up a corporation or a limited liability company for individuals. Perhaps the transaction is something to do with giving legal advice. Giving preparation. I know I could find that word. I apologize. Preparation of copyright or patent applications. And then lastly, providing legal advice. And sometimes the lawyer is only called upon to give legal advice, and it's not connected with a litigation and transaction. But, excuse me, in all instances, that lawyer is involved in some activity involving the practice of law. And when we look at paralegal activities, we could, and I'm going to let you scroll through this yourself, but we could certainly see how paralegals, whether it's litigation or whether it's transactions, can help attorneys engage in those activities that we've identified. And let me just bring this down to earth sort of in two ways. Number one, in New York State, when people buy and sell a house, the buyer is represented by a lawyer. The seller is represented by a lawyer. Typically, the buyer has to borrow money to make the transaction happen. And the lending institution, the bank, for example, will be represented by a lawyer. But for all three law offices involved, we're going to see the bulk of the work being done not by the attorneys but by the paralegals. I would go so far as to say a lawyer or a law firm could not operate a profitable real estate business without the extensive use of paralegals. If we go into the litigation area where I've had experience working with paralegals, including graduates of the ECC paralegal program, I can tell you that whether it's participating or helping me participate in discovery, getting information relevant to the case before a possible trial, doing legal research. I've had paralegals do terrific legal research jobs for me, and actually helping drafting some of the basic documents for litigation. So when we look at what the activities lawyers are engaged in, we're going to find that more and more there's one or more paralegals who are really providing invaluable assistance to the attorneys. And we'll close this video out at this point.